Welcome to Innovate Training. I'm glad you joined me for this course called Understanding HIPAA for the Medical Office. This is the second lecture in this course titled Privacy Issues Explained. My name is Carol Peugeot and I'm your instructor for this course. This lesson concerns the privacy rule, which is one of the most important aspects of HIPAA for the healthcare provider. So what are we going to talk about today? Well, first we're going to talk about the definition of protected health information, or PHI. And then we're going to talk about when it is and when it is not appropriate to disclose protected health information. Then we're also going to talk about when it is appropriate to disclose protected health information in order to conduct the business of the healthcare provider. And then finally, we'll discuss what the minimum necessary means when it comes to disclosure of protected health information. Well, in today's information-driven society, information is being collected constantly. Stores track our purchases when you slide your membership card or use your credit card. Internet providers track your browsing activity online. Have you ever noticed that pop-up ads often match the very things you've been looking online at or Googling? Financial institutions track your credit history and buying history. A federal law about the safeguards of protected health information is necessary in order to protect patients' rights. Otherwise, we would be at risk of losing our rights to personal privacy. The Department of Health and Human Services, or the DHHS, wrote the privacy rule to mandate nationwide standards to protect private health information. We're going to work through this privacy rule and discuss what it is and what it is not. There have been many policies in place to help protect patients' privacy. However, these often were not mandated and only subject to each facility's interpretation of privacy. The Department of Health and Human Services has then set a standard or a universal definition of what it means to protect patients' privacy. Each healthcare provider must have certain policies in place to comply with this ruling. Each company is responsible to set into place their policies regarding how they're going to comply with the HIPAA privacy rule. This includes all healthcare workers, whether or not they transmit healthcare claims electronically. Now, while the transmission of electronic health information was the creator's original intent for this rule, it pertains to any type of health information, and that's why it pertains to appointment books, recall reminders, and other types of written correspondence. The privacy compliance of the healthcare provider requires training of the staff to understand this ruling. Again, HIPAA doesn't dictate how each company should conduct its training, but requires that each employee is trained properly in HIPAA. In other words, whether they are trained by an in-service or go to a seminar or go through an online training session such as this one, as long as the training meets the standards of HIPAA and is documented in the patient's record. The Office of Civil Rights, or OCR, the Department of Health and Human Services, Office of Civil Rights. They're responsible for administering and reinforcing the HIPAA standards and may conduct compliant investigations and compliance reviews. The Office of Civil Rights is responsible for the enforcement of the HIPAA privacy rule. If the OCR conducts an investigation, inspectors will expect to see written or electronic healthcare facilities policies. In other words, they're expecting to see some type of documentation of the facility's policies regarding patients' privacy, whether this is in a written format or whether it's electronic posting. They're expecting to see some type of documentation of that. They're also expecting to see some type of proof of training on the HIPAA's privacy rule, as I mentioned earlier, whether this is an in-service, whether it's an online, or whether it's a classroom session that the workers attend. They're expecting to see some type of proof of training and that documentation of that training. Let's talk about the privacy rule's intent. The privacy rule is flexible enough to allow each organization to do what is reasonable within the guidelines. As I mentioned earlier, HIPAA's privacy rule allows the company to perform under their own policies as long as they meet the HIPAA goals. For example, when a physician speaks to a patient, it's not so stringent that it requires all conversation to be held in a room with a closed door. HIPAA's purpose was not to unreasonably interfere with the activity of the medical office. So think of it more as a redirection in attitude and a way of keeping the patient's privacy always on the mind of the healthcare professional. When was the last time you were in the doctor's office and you could easily see the information on the receptionist's computer screen? Or when was the last time you were there and you saw the names of the other patients who were visiting the office on the sign-in sheet? Now, while these are not necessarily gross HIPAA violations, they are infractions and could leave the patient's information at risk, as well as leave the practice at risk for violating the patient's privacy. So let's look at a scenario. Mrs. Jones goes to Dr. Garcias' office. Mrs. Jones notices that the name on the sign-in sheet next to hers is her neighbor's. She asks the nurse how her neighbor is doing with her chemotherapy, and the nurse states she is doing fine now that the doctor has changed her medication. Is this a gross violation? And at what point does it become a gross violation? Well, the answer is yes, it is. But at what point did it become a violation? Did it become a gross violation at the point of the sign-in sheet? Well, not really. At the point of the sign-in sheet, as I mentioned earlier, while it's an infraction, it's not necessarily a gross violation. Did it become a gross violation at the point where the nurse said the patient was doing fine? Again, not necessarily. That was very general information, and although it could have been considered an infraction, not necessarily a gross violation. Where it becomes a gross violation is where the nurse gave specific information regarding that patient. Title II. The HIPAA Public Law 104-191 was enacted on August 21, 1996. Title II has the title of Preventing Healthcare Fraud and Abuse, Administrative Simplification, and Medical Liability Report. The goal of this ruling was to protect health information while still allowing the flow of health information to properly and effectively treat patients. So what is protected information? The privacy rule protects all individually identifiable health information. This is information that identifies the individual for which there is a reasonable basis to believe can be used to identify the individual. It simply means any information that can be traced to a particular person. This, the privacy rule calls protected health information, or PHI. What is protected health information? An efficient way to determine if health information is to be protected is to consider, can there be an association between the health condition and the individual? So let's look at some examples. The first one is, a pharmaceutical company calls and asks the practice for how many patients are on an arthritis medication. Is this information identifiable? In other words, could any of this information given to the pharmaceutical company be traced to an individual? Well, the answer is no. The pharmaceutical company only wants a number of patients, so none of that information can be traced to a particular patient. So let's look at another example. A medical supply company wants a list of patients who are currently using oxygen on a regular basis. Is this information identifiable, and is it a violation? The answer is yes to both questions. It is information that can be identified to a particular person because the oxygen supply company wants a list of patients. They want a list of patients' names. And yes, it is a violation because this information is protected. So let's talk about de-identified health information. De-identified health information neither identifies nor provides a reasonable basis to identify an individual. De-identifiers have been specifically removed. In other words, information such as their name, social security number, medical record number, address, site of birth, date of birth, sibling information, and parental information. All these pieces of information have been removed so that it's been de-identified. De-identified health information is that which these identifiers have been removed, and so the information is very general. It might be a list of 40-year-old males or 50-year-old females. but it doesn't have any information that identifies specific information. For example, the pharmaceutical company may want a list of patients on high blood pressure medicine. As long as they give a list of patients that do not have any identifiers on them, such as a list of 30-year-old females, 50-year-old males. This information can be given as long as information such as name, address, date of birth, and so forth has been removed. Let's talk about a basic principle. A major purpose of the privacy rule is to define and limit the circumstance in which an individual's protected health information may be used or disclosed by covered entities. A covered entity may not use or disclose protected health information either except as the privacy rule permits or requires, or as the individual who is the subject of the information or the individual's personal representative authorizes in writing. Let's talk about disclosure. This is the release, the transfer, or provision of, access to, or divulging in any other manner of information outside the entity holding the information. Now, under the privacy rule, there's certain permitted uses and disclosures. First permitted use is to the individual. A covered entity may disclose protected health information to the individual who is the subject of the information. They also may use the information for treatment, payment, or healthcare operation. A covered entity may use or disclose protected health information for its own treatment, payment, or healthcare operation activities. As we mentioned earlier, HIPAA was not meant to disrupt the business of the healthcare, and it was not meant to interfere with patient care, but rather provide protection for patients' health information. A covered entity must obtain the individual's written authorization for any use or disclosure of protected information or protected health information that is not for treatment, for payment, or healthcare operations otherwise permitted or required by the privacy rule. Let's look at a couple scenarios. Under the privacy rule, does the healthcare provider need the patient's signature before they can bill the patient's insurance carrier? Well, the answer is technically no, since the purpose of HIPAA was not to disrupt the business of healthcare, and billing a patient's insurance carrier falls under the authorized use of information. The answer is no. Another scenario. Under the privacy rule, does the physician need the patient's signature in order to discuss the patient's case with his or her attending physician? Again, the answer is no. This falls under the authorized use for treatment or healthcare operation. If HIPAA interfered with the communication of health information between providers of care, that would mean that the patient's care would be disrupted. And so HIPAA was never meant to disrupt the patient's care or the operations that need to go on in order for the healthcare business to continue. Let's talk about another scenario. Under HIPAA's privacy rule, does the provider need the patient's signature in order to discuss the patient's medical condition with the patient's employer? Well, the answer is absolutely yes. I would hope that my physician would not release any of my health information to outside entities, such as an employer, current or prospective, without my expressed permission. Let's talk about the minimum necessary clause. This means that a covered entity must make reasonable efforts to use and disclose and request only the minimum amount of protected health information needed to accomplish the intended purpose of the use, disclosure, or request. In other words, only the information for the specific purpose should be disclosed, including those uses that are authorized, and including information used for billing and healthcare operations. So this is very important. When the patient gives permission to disclose his or her private health information, whether it is stated or not, the healthcare provider should only disclose the necessary information needed to accomplish that specific task. Okay, in the last little bit, let's talk about authorization versus consent. How does authorization differ from consent? Well, authorization gives permission to disclose protected health information for reasons other than treatment, payment, or healthcare operations. Authorization must always include specific elements and other specific information, specific to dates and specific to treatments or diagnoses. Whereas consent is an agreement to receive treatment with the understanding that protected health information will be used for treatment, payment, and normal business operations. HIPAA and consent. Consent is more in the realm of patient care and treatment and does not fall under the privacy rule. Any disputes regarding consent would most likely be a malpractice civil case and maybe even a criminal case, depending on how grievous the wrongdoing is. So consent would have to do more with the patient care and not with patient's privacy. So in summary, the privacy rule was created to protect patients' health information. We talked about what protected health information is, and we also discussed the times when disclosure of protected health information does not need authorization, such as when in order to conduct business for billing purposes and also as the privacy rule dictates. We also talked about what minimum necessary means. Minimum necessary means that you provide only the information specific for that particular task. And finally, we talked about the difference between authorization and consent. Well, I hope you enjoyed this section 2 of Understanding HIPAA for the Medical Office. Next session, we're going to be discussing the Security Act. So please join us for that as we talk about the measures that need to be set into place to provide patients' privacy, and that's included under the Security Act. Again, please feel free to contact me with any questions or comments. You could email me at innovatraining@gmail.com. Please be sure to take the assessment quiz that follows this lecture. And please take time to answer these questions, as these questions will be helpful for you when taking the final exam at the end of this course. So this is Carol Peugeot for Innovate Training, and we'll see you in session 3. Bye.